Before the U.S. Civil Rights Act passed in 1964, it had been written to protect Americans from discrimination on the basis of race, religion, color, or national origin. The bill was controversial. Not all politicians wanted to see it go through. And one of those people was a representative from Virginia named Howard W. Smith, who proposed an amendment to insert the word sex. He snuck it into Title VII of the bill, which protects people from discrimination at work. And he did it because he thought that adding sex discrimination protections would make the bill so unpopular that it wouldn't get enough votes to pass. But it didn't work.
Congress passes the most sweeping civil rights bill ever to be written into the law.
Instead, the inclusion of the word in the Civil Rights Act set up a different battle. Because the Civil Rights Act says nothing about sexual orientation or gender identity, for the past 50 years, the U.S. has been debating the legal definition of sex and whether it protects LGBTQ Americans from discrimination too. That answer depends on who you ask, and it hangs on the outcome of the 2020 election. What sex discrimination meant in the context of the Civil Rights Act of 1964 was that women, who were becoming a larger part of the workforce, couldn't be discriminated against just because of their sex. At the time, it didn't explicitly protect LGBTQ people, but over the years, a wave of activism and a string of legal battles helped interpret the Civil Rights Act to include protections for LGBTQ Americans. And it all came down to the word sex and what it means to discriminate on that basis.
It's been a way for us to obtain protections, through litigation that we have not been able to obtain explicitly through congressional action.
This is Sasha Bookert. She is a senior attorney at Lambda Legal, which litigates sex discrimination cases for the LGBTQ community.
The pivotal case would be Price Waterhouse v. Hopkins.
The Supreme Court ruled on it in 1989, and it helped expand the definition of sex discrimination.
It involved a woman named Ann Hopkins who was worked at an accounting firm and who, by all accounts, was highly successful.
Ann was competing against 87 male applicants for a promotion to become partner, and someone from the hiring committee told her how she might get the job.
Dress more femininely, get her hair styled, wear jewelry, and there were other folks who, were throwing around words that she was, quote, macho.
She was rejected for partnership twice, so Hopkins sued her company using the sex discrimination clause in the Civil Rights Act. And she won, which expanded the kind of discrimination that Title VII can protect against, based on something called sex stereotyping. The court ruled that an employer who acts on the basis of a belief that a woman cannot be aggressive, or that she must not be, has acted on the basis of gender. And in 2004, another court ruling expanded this logic even further to explicitly protect a trans person.
The Smith decision involved a firefighter in Salem, Ohio, who came out, had a pretty stellar record. She began her gender transition, meaning that she was born male and was transitioning, to live in accordance with her female gender identity.
Ms. Smith sued her employer for sex discrimination when she found out she would be fired. And she won, based on the argument that discrimination against someone who doesn't identify with his or her gender is no different from the discrimination directed against Ann Hopkins, who, in sex stereotypical terms, did not act like a woman.
So that was a significant victory, especially at the time. I think it's important to remember the courage, of someone, to take that step in in the early 80s in a firefighting outfit.
These cases have helped protect countless members of the LGBTQ community who have had to fight these legal battles in the absence of a federal law that grants them protections.
There's no substitute for those explicit protections. I lived in California and I lived in Oregon, and, there's just no ambiguity about the fact that trans people are protected under the law in those states, and that's the way it should be federally.
Oregon and California are two of the 27 states that have non-discrimination laws based on gender identity or sexual orientation. One state only has sexual orientation protections, and 22 states don't offer any protections at all. That ambiguity makes the position of the White House on this issue really important. Starting in 2014, the Obama administration signed executive orders to reflect how sex discrimination was being interpreted in the courts. and those rules impacted all these federal agencies. For example, the Department of Justice wrote that the best reading of Title VII's prohibition of sex discrimination is that it encompasses discrimination based on gender identity, including transgender status. The Department of Defense said that transgender individuals shall be allowed to serve in the military. And the Department of Education issued a letter that said schools that receive federal funding should allow students to use the bathroom that aligns with their gender identity. But in 2017, when President Trump took office, his administration reversed all those rules, explicitly saying that discrimination does not encompass gender identity, meaning sex is limited to biological sex determined at birth. And that contradicts how the courts have evolved over the past 50 years.
If you're going to just decide to take steps like that without complying with the rule of law, that's really dangerous for our democracy.
Then, in 2020, came another Supreme Court case that made the court's interpretation even clearer.
A major civil rights decision out of the United States Supreme Court. The biggest opinion for gay rights in this country since 2015, when, of course, same-sex marriage was legalized.
The case involved a juvenile court employee in Clayton County, Georgia, a state that doesn't offer LGBTQ discrimination protections.
It was my dream job, doing what I loved and making a difference on the lives of children that came through the system. Then one day, after 10 years of employment, I decided to join a gay recreational softball league. And within 6 months of making that decision, I lost my job. I lost my job because I'm gay. I was devastated. I lost my income. I'd lost my medical insurance, and that was a time when I was still recovering from prostate cancer. So it was a very difficult time.
A man who says he was fired from his job because he's gay takes his case to the U.S. Supreme Court tomorrow.
As I started seeing it on television,
the Supreme Court has ruled that LGBT Americans are protected by the anti-discrimination laws.
My heart stopped for a moment. I was just elated.
A landmark ruling for gay and transgender workers.
The LGBTQ plus community celebrated outside the Supreme Court today.
It opens the door for all kinds of lawsuits against discrimination.
This decision made the court's logic on LGBTQ protections explicit. Sex discrimination includes discrimination for sexual orientation, too. The legal fight for LGBTQ people to be protected from sex discrimination took half a century in the courts. But whether the White House acknowledges that evolution will depend on the outcome of the 2020 election.
It does send a message, to people in the community that they're not protected, and it invites people to discriminate and just creates a hostile environment.
Joe Biden has given every indication he plans to reverse Trump's rules on his campaign site and in town halls.
How will you, as president, reverse this dangerous and discriminatory agenda and ensure that the lives and rights of LGBTQ people are protected under U.S. law?
I will flat out just change the law, eliminate those executive orders.
That change would acknowledge what the courts have decided, that the definition of discrimination based on sex should include the LGBTQ community, instead of leaving them to continue their fight. Thank you for watching this episode of our 2020 election series. We asked you what you think the candidates should be talking about, and LGBTQ rights was one of the most common requests. Stephen asked, what do my rights look like being in the LGBTQ plus community if Biden or Trump get elected? Kayla asked about LGBTQ rights beyond gay marriage, like protecting same-sex couples' right to adopt and preventing discrimination in schools and the workplace. And Mattia asked about the future of queer rights, specifically regarding the trans community. We're nearing the end of this series, and the election is just around the corner. You can watch all the videos in this series at vox.com/electionvideos. We'd also like to thank our sponsor for this video, Absolute, who wants every American to make their voice heard this election by casting a vote. Absolute doesn't have a say in our editorial, but they do make videos like this possible. So remember to vote responsibly and drink responsibly.